They're chipping away at that big block into which all J6 defendants have been lumped. I get a lot of questions about these cases all the time from all different types of people, from all different walks of life. Hello, it's Lana Manitta with Rossen Law Firm again, here to talk to you today about the two questions that I get the most from people regarding the January 6th prosecutions that are taking place in the United States District Court for the District of Columbia, where I practice regularly and where I have represented a number of defendants charged with January 6 or J6 offenses. Before we dive into the questions, remember to like and comment on this video and subscribe to our channel, where we provide educational videos on a wide variety of criminal defense topics. So, as those of you watching may or may not know, while Rossen Law Firm is headquartered here in South Florida, we have federal criminal defense attorneys who represent clients in matters throughout the federal court system, especially here in Florida, but also elsewhere in the United States, including especially the courts that I have practiced in for many, many years, the Eastern District of Virginia, the so-called Rocket Docket, and the District of Columbia. So the District of Columbia is where the January 6th cases, the cases arising out of what happened at the U.S. Capitol on January 6, 2021, are being prosecuted. And I get a lot of questions about these cases all the time from all different types of people, from all different walks of life. Some people have really accurate information about that day. Some people have inaccurate information about what went on that day. Some people don't know anything about it, and frankly, some people have completely made up what they believe may have happened that day. So rather than making everybody happy, which is impossible, I'm going to try to address the two questions that are fairly universal that I get most often. And the first one is put rather simply, what did people do wrong? Now, I'm not going to answer this from a philosophical or moral standpoint. I'm going to answer, I think, the question that folks are asking, which is, what laws does the government say these people broke? And so I'm going to cover the statutes that the U.S. government has been using to prosecute individuals who were at the Capitol on January 6th. Because by and large, the majority of defendants are charged similarly, but there are a number of statutes that are being used and applied to varying levels of conduct at the Capitol on January 6th. So the first one, and I think it's one of the more common charges, is the statute 40 U.S. Code 5104. There are two specific subsections that are being used in these January 6 prosecutions, but we'll start with E2G, which is parading, demonstrating, or picketing in any of the Capitol buildings. Seems pretty straightforward, but as the litigation on these cases will tell you, it's not always straightforward. But that seems to be the most common statute that people are charged under. The second most common is, and I may be off by a few because there are thousands of prosecutions, but the second that I believe is most common from the research that I've done is under 18 U.S.C. 1752. And again, this is a statute that has two subsections that are being used. And primarily, mostly we're seeing A1, which is knowingly entering into or remaining in any restricted building or grounds without lawful authority to do so. The other subsection of Section 1752 that's being used for prosecution is A2, which prohibits knowingly and with the intent to impede or disrupt the orderly conduct of government business or official functions, engaging in disorderly or disruptive conduct in or within such proximity to any restricted building or grounds when or so that such conduct in fact impedes or disrupts the orderly conduct of government business or official functions. Now, if you've watched some of our other videos, especially mine, you're probably thinking, now that sounds a lot more like a federal statute than the others because it is long, it is winding, it is confusing, it's a bit repetitious. And what we do as criminal defense attorneys is really pick it apart word by word by word to make sure that what the government is alleging that a client has done actually fits the wording of the statute. And then it's reading case law to see if this statute has been used to apply to the type of conduct that is being applied to in the past, and maybe even the legislative history of the statute to see if it was passed with the purpose of going after that particular kind of conduct, or was it really aimed at something else? And that's going to be relevant to our discussion in just a little bit. The other subsection of 5104, which again is 40 USC 5104, that is being used is E2D, which is uttering loud, threatening, or abusive language, or engaging in disorderly or disruptive conduct at any place in the grounds or in any of the Capitol buildings with the intent to impede, disrupt, or disturb the orderly conduct of a session of Congress or either House of Congress, or the orderly conduct in that building of a hearing before or any deliberations of a committee of Congress or either House of Congress. Again, there's a lot there. It's much more straightforward than the wording would suggest because it is very long-winded, but it is basically disruptive, disorderly conduct in the Capitol building that disrupts the business of what is done in the Capitol. The next statute that is being used, really not as often, but it has come up, is 18 USC 875C. And this involves the transmission in interstate or foreign commerce. And again, if you've watched some of my other videos, you'll know that's a really key phrase to congressional authority to legislate a crime, is if it affects interstate or foreign commerce. So this is a statute that prohibits the transmission in interstate or foreign commerce any communication containing any threat to kidnap any person or any threat to injure the person of another. And that was used in a limited number of cases, but a few cases involving some communications online on social media and text messages that involved, sort of boasting about what folks wanted to do and to whom when they got to the Capitol that day. Another statute that's been used, again, not as often as the disorderly conduct statutes or the picketing, parading, being on the property when you weren't supposed to, is 18 USC 641, which is the theft or conversion of government property, specifically federal government property. We've also seen a number of serious prosecutions under 18 USC 111, A1, and B. And the reason these go together more than the other subsections is 111A1 is assault on an official or an officer, and B provides for an enhancement if a deadly or dangerous weapon is used in the assault of an official or an officer. And the judges have been finding that pepper spray, which was used by a number of individuals who were present on January 6th at the Capitol, the judges have by and large been finding that that qualifies. There were other individuals charged with 18 USC 372, which is conspiracy to injure an officer, 18 USC 1361, destruction of government property, 18 USC 231 A3, which is the obstruction, the impeding or interference with a law enforcement officer who is lawfully engaged in his official duties during a civil disorder which obstructs, delays, or adversely affects the performance of a federally protected function. There are also a small number of individuals who were charged with seditious conspiracy. This is probably the most serious charge, frankly, with the amount of time that it carries that folks were charged with, and that's the statute 18 USC 2384. Now, another one that was very commonly used, and I'm saving it for last because it's relevant to another discussion that we're going to have in a separate video, is the statute 18 USC 1512 C2. This involves the obstruction, influence, or impeding of any official proceeding or the attempt to do so. Now, this was the subject of a recent notable Supreme Court decision, Fisher versus United States, in which the Supreme Court narrowly interpreted that statute, that subdivision of that statute, really favorably to defendants. And there are over 330 defendants who have been charged, are currently facing this charge of a violation of 1512 C2, including Donald Trump. So, as you can see just from this little summary, the government is applying a wide variety of statutes to conduct on that day. And most people have started out charged with multiple offenses, either 4 misdemeanors or some combination of 1 felony and some misdemeanors, and in some very serious cases, multiple felonies and multiple misdemeanors. Many, many people have entered guilty pleas to reduced number of charges, not necessarily reduced charges, but reduced number of charges. So in other words, they're charged with 4 felonies and they're able to plead to 1 or 2. And they're able to plead to the 5104 misdemeanors that carry a max of 6 months instead of the others that carry a max of 12 months. And of course, many, many defendants have gone to trial, and there are some cases that are up on appeal, including obviously Mr. Fisher's went all the way to the Supreme Court. So the next question that I get most often is what kind of sentences are being handed down by the judges in DC on these cases. And in the early days, the government would recommend probation for those who pleaded early to misdemeanor counts. But then at some point, there was a change in policy, and the decision was that their office, the U.S. Attorney's Office for the District of Columbia, would not recommend probation for anyone at all, regardless of how short the time is between arrest and decision to plead guilty or any other mitigating circumstances. The good news is that the court still seems to be imposing probation sentences despite the government's not recommending them. But it's now very safe to say that 3 years into these prosecutions, there's certainly no presumption in favor of probation for defendants, even on the least serious of charges. And on the more serious charges, whether it's through a plea or a conviction at trial, the court is most certainly imposing jail sentences. Now, where incarceration has been imposed, the sentences have ranged widely. And there are sentences that are days or maybe even a couple of weeks in home detention, all the way up to 20 years in prison. The attorneys that are handling these cases, including myself, are tracking on a near daily basis the developments and the way that judges and juries are responding to different arguments in pretrial motions, sufficiency arguments, and sentencings. Appellate cases are beginning to develop at least some narrowing of the issues, but the landscape is still very treacherous for the J6 defendant and requires an experienced guide, as it were, an attorney who knows what they're doing with these cases, knows what they're doing in the DC court. Each judge, and it's a large court, has a different, although not dissimilar, take on J6 and those who went to the Capitol that day for any purpose at all. And it's really important to be aware of the judge's position, the judge that's assigned to your case, their position on the law and the facts. What have they said to people at sentencing hearings? What is their take on what happened that day, not just how they ruled on certain motions? Because you don't want to find out that for the first time at trial or sentencing, that judge's view on J6. Now, if you've seen some of our other videos on pretrial motions, you're probably wondering, well, why not just try to change venue out of DC? But that's a decision that's in the discretion of the court, and a case can be tried wherever venue is proper. So, folks have not been successful in getting these cases tried elsewhere. The evidence, the witnesses, especially the enforcement witnesses, they're all in DC. And, it certainly makes things a little bit more difficult for defendants when the building is not only right across the street, but you can see it from the cafeteria. So when jurors go to lunch, they're looking at the building that they're hearing about during trial. But there have been strides made by the attorneys fighting these cases. They're chipping away at that big block into which all J6 defendants have been lumped. And we're making distinctions between individuals. We're progressing on more favorable interpretations of the law. But there are many more prosecutions in play right now and more to come. And so there's more work to be done by defense counsel. If you or someone you know is facing charges related to J6 and needs to talk to an attorney, contact us and set up a consultation in person, by telephone, or via Zoom. In the meantime, stay tuned to our channel for more updates on this compelling topic and educational videos on various other criminal defense topics. And remember before you go to like and comment on this video and subscribe today. Thank you for watching.